The next speaker, we are privileged to welcome Mr. Samir Shah, a seasoned advocate, arbitrator, mediator, and a visionary in the field of ADR with nearly 3 decades of legal practice. He's the founder of SU Shah and Associates in Ahmedabad and the ADR BAR, and serves on numerous prestigious panels, including the Court of Arbitration for Art in the Netherlands and the Gujarat International Maritime Arbitration Center. Mr. Shah is also a co-founder of NRAP India chapter and a faculty member for mediation training at IM Campus, Germany, actively promoting area practices both in India and internationally. His extensive cross-border advisory work and dedication to mediation education has made him a respected figure in the global area community. We are honored to welcome Mr. Samir Shah to share his perspectives on area ecosystems in the United States and to contribute richly to today's deliberations. Over to you, sir.
Thank you, Shakti, and thank you, Inba, for this kind invitation. I hope I'm audible enough.
Yes, sir.
All right. So, a very good morning to all of you, and it's almost good night for me here in the US. But yeah, thank you so much for this invitation and inviting me to speak on, of course, my passionate subject of ADR, and especially on a very, very developed jurisdiction, USA. I mean, I came here 2 years back, so I'm doing both India and US side. Though I'm not yet licensed in US, but I still do constantly for my Indian work here. Now, I just give you briefly an overview of the US arbitration scenario. Probably quite few of you would be aware about it, but for a general understanding, so US, as I said, is a quite developed, very developed, I would say, jurisdiction so far as dispute resolution through arbitration is concerned. Arbitration here in US is very, very extensively, implemented, followed for dispute resolution in practically all major industries, you name it, be it technology, finance, consumer, construction, and so on and so forth. So it is very extensively being used for resolution of disputes. And the main legislation through which arbitration is governed is the FAA, which is the Federal Arbitration Act, and it governs the institutional arbitration. And now US has so many renowned arbitration institutions. So the majority of the arbitrations are done through institutional arbitration. You name it, and they have the best of the institutions here, like AAA, ICDR, ICC, JAMS, CPR, NYIAC, and so on and so forth. And all of them have quite a robust system of dispensation of dispute resolution through arbitration and mediation as well. Now, apart from this federal legislation, each state has its own state legislation for arbitration, which of course supplements FAA. And the US courts have also been favorably implementing, and supporting FFA and dispensation of arbitration. Now, some of the recent trends so far as arbitration concerned in the United States is, I would just mention a few of them which are very important. The first being summary adjudication. Now, there is an increasing trend towards summary adjudication of claims where the claims are devoid of any merit. And institutions like ICDAR AAA have extensive, rules provided under their provisions for summary adjudication. The next is, of course, a very important aspect is the diversity and inclusion, which is also gaining much popularity and increased attention across the arbitral world here in US. Of course, post-COVID, as is in other parts of the world as well, virtual hearings have been again given more importance, have been on increase for in US as well. Then emergency arbitration, of course, many other jurisdictions also are focused on this. Same in US. One aspect which is more, I would say, in my experience, which I've come across is which is growing on a a much larger scale and more focused way is AI in arbitration. It's a very interesting, concept of or the process. And I know there are debates going on about the pros and cons of using AI and to what extent one should be, implementing it. But if we take on a positive side, AI, of course, is very helpful, I would say, in large complex cases. So far as discovery, streamlining the case management is concerned. So if the AI is used in that manner, and which is being, I mean, which is actually being used here in US by institutions like James, and the Silicon Valley Arbitration Mediation Center. So I think AI is the, I would say, a future of dispute resolution so far as in a facilitative mode. I would say not that we totally depend on AI, but it definitely gives a much facilitative role play for effective dispute resolution mechanism through arbitration. Um, as I said, there the institutional arbitration definitely has been in focus and is the basis of dispute resolution through arbitration in US. And US being also party to many treaties and conventions like Inter-American Convention on International Commercial Arbitration, which is known as Panama Convention, Convention on Settlement of Investment Dispute, of course, ICSID, North America Free Trade Agreement, NAFTA, and so many such treaties which also provides for dispute resolution through arbitration. Another aspect is what is known as default awards under the US system, where if the respondent fails to appear in spite of court directions, then the tribunal can make a default award and which are enforceable. So that's a very important and aspect of arbitration in US. Uh, Considering the current geopolitical and international trade situation, which also has given much more focus to international arbitration in US. Now, as I was telling you about AI, now it is again being very extensively being used in US so far as our international arbitration is concerned, especially generative AI and large language tools, which facilitates arbitration process, especially document review, e-discovery, search analysis, and summation of large database, indexing of exhibits, visualizing complex information sets. So as I said, this definitely is helpful so far as effective case management is concerned. And therefore, institution like AAA has introduced even what is called the Clause Builder AI, which is a tool which uses database of clauses and provide arbitration clause building services. Then it also has introduced triple AI panelist search, which helps the parties or the counsels to to effectively, or in a very better way, search for the panel selection process. So, yeah, in a nutshell, I would say that things are definitely much advanced and developed in US. So far as arbitration is concerned, US, of course, is again a common law jurisdiction. It follows the model law in most of the aspect, but and the courts also have been very pro arbitration so far as dispute resolution is concerned. Over to you, Shakti. Sorry.
Uh, yes,
Yeah.
yes, Samir. Thank you. Thank you for sharing the perspective of arbitration, which is so well structured. That's what we can understand from your presentation in US. Here, at this point, we are very much interested to invite you. Why? Because the connect what you have, that is the India and US connect. For the information to most of the audience and co-panelists, Mr. Samisha is a very prominent lawyer, I can say, a litigating lawyer who has accepted, that's very important, who has accepted that ADR is going to be the future. Alternative dispute resolution, the mindset of a litigating lawyer, how it shifts from the traditional litigation to ADR, particularly the mediation front.
Yeah. I agree. I agree. Completely agree with you.
Yeah. This is very much required. The very objective of the mindset, what we call, and as a former colleague with in the Chartered Institute of Arbitrators, where been long for more than a decade in the India branch as well as the Asian arena, the objective of this shift from litigation to ADR is very important. Starts from the training point.
True.
The stakeholders, significantly the lawyers or legal representative appearing before the tribunals or the arbitrators or the mediators, the effective training makes a standard. If the standard is there, obviously this can be structured very well. And that is the takeaway what Mr. Shah wanted to share. Anyway, being a larger global North player, US, whether it is going to be the Federal Arbitration Act of US or the other state legislations on the ADR front, along with a very prominent institution that is AAA, American Arbitration Association's unit of International Center for Dispute, ICDR. I'm with that few informations, what I know personally and what has been given elaborately by Mr. Samisha, this Global South Alliance would need a lot of support from you, being the
Sure.
promoter or pioneer of the concept of ADR bar in India, which has now been evolved as the Arbitration Bar of India. You happen to be the front runner for this task, which is going to spread not only in the aspect of a very small jurisdiction, we had to larger make it as a global arbitration bar. With that point, I think there is a couple of expected questions, which...
But let me, let me just add one thing which you just mentioned, which is very important, which is the current US-India trade relationship. Now, it's really growing on a much larger scale than it was before. But as we all know, with the growth of trade, there are bound to be, disputes arising out of those relationships. But so it is very interesting to, see how all this relation develops and what happens in future so far as trading relation is concerned. See, right now everything is going very positive and we hope that it goes with that way, but you never know. I mean, trade, there's always all the chances of disputes coming up. So how those disputes are being tackled, resolved, attended to. That is, I think, is a very important aspect which we need to look forward to. And secondly, again, what you very uh, correctly mentioned is the the aspect of mediation in ADR. And in my experience, what when I've been interacting with colleagues down here in US, I think in US also there is a big shift of focus from arbitration to mediation, so far as dispute resolution is concerned. And I have seen, and I've been even you've been part of many such programs, the trainings basically. So each state, each state bar association is going through, especially New York, which is very active and prominent so far as ADR is concerned, and mediation for that matter. Down south is, of course, California bar is again very proactively involved in ADR and mediation. So mediation is, again, I think we need to also lay focus. Of course, there's a big change for a positive side. So while mediation comes in India with the act coming in play, so I think we need to focus also and give that importance to mediation for effective dispute resolution.
Yes, well said, Mr. Samir. With this note, I wanted to bring to the audience as well as the panelist, one of the global south country, obviously Singapore, which initiated this mediation to a larger scale in the 2018 dialogue, what I can personally look upon. And when in 2019, the Singapore Convention was signed by more than 40 countries, the initial introductory date itself, a global south country looking into this particular mediation in a serious note, much ahead from the other developed or the economies which are having a larger history on this ADR. The concept of mediation going along with international settlement agreements, which has been emanated out of those mediation, is in the pipeline of multiple jurisdictions, particularly whether it is going to be Qatar, whether it is going to be Iran, whether it is going to be Belarus, Ecuador, China, many countries, including India also. They have now started ratifying this particular convention, bringing in the mediation legislations, which is a shift from the traditional conciliation in most of the global south jurisdictions, now started adopting these mediation predominantly in all type of disputes. That's very important. As rightly pointed out, the traditional aspect of the dispute, which were trade disputes, now moving to multiple other disputes. There might be exception. The Singapore Protocol, which avoids the personal disputes, the family disputes, the reservations on sometimes which has been recommended for a sovereign state's involvement. Other than these, this particular protocol, which if it has been taken in the manner how it was prepared, I think the whatever the jurisdiction, they will be a valuable contribution for the growth of ADR. Mr. Samir, if you have some more thought on how this the present trade issues which is happening with the jurisdiction where you are right now practicing, to what extent, whether it is the tariff regimes, whether the aspects of relooking on various trade arrangements or negotiations or deals, or having an amendment or mutations in the free trade agreements, all sorts together, US with all the jurisdiction. It's a well-known fact that US having or acting as a major trading partner with all the developing or the developed economies, to what extent you feel, particularly on the context of applicability of mediation and arbitration in such dispute?
Alan, I think it's a very interesting question, and um, if we look at the current situation, what happened post the tariff levies by the U.S. government, I would take that in a positive way of what happened thereafter between different government having dialogue and conversation with US. So it's a sort of negotiation. What happens in mediation? Yeah, the negotiation is a very important part of mediation for that matter. So I would look this post-tariff situation as a sort of negotiation happening in a mediation, in a mediated dispute. Though there is no dispute per se as we see it, but of course there are differences, the between different countries with the U.S. Outlook to tariffs. But what happened and what is happening when the government of different countries are coming along, sitting with the U.S. government and trying to work around this tariff issue is nothing but, I would say, negotiation tactics, which of course is very important for a government to adopt that, maybe for its own benefit. There's nothing wrong. So you see, ultimately, every government works for its own benefit, for the benefit of the country, for that matter. But if this kind of a situation, this kind of a negotiation is being positively worked around, positively being taken into account, I think major trade issues across the globe could be very effectively resolved on a larger extent. And in fact, I was really thinking it's good that you came up with this suggestion. I would say, I would suggest that why mediation be not being used in the current Russia-Ukraine situation. Why? So what is happening? We have across so many renowned mediators, yeah, people who can influence, but why it is not happening? Either is it that there's something very wrong with the situation, but even if that, we know how to negotiate, how to come out of a difficult mediation. Of course, mediation cannot be successful every time. That's accepted, but has that been effectively being used in the current situation between Russia and Ukraine? So I think that could be a good test for promoting mediation in international disputes.
Yeah, well said, Mr. Samir. This makes me to get back to the history or epics about Mahabharat. Many of you, the audience coming beyond the Indian diaspora, it is a very interesting epic, Mahabharat, wherein there was a god by name Lord Krishna. He tried this mediation technique, quite historical period, according to the historians. There also there was an effort, whether it is going to be the geopolitical issue or even the trade issues, there was a try. But that try reasonably made certain conclusions in a successful manner. Why not? It can be adopted in the present day civilized society. Mr. Samir, it's a valuable point what you mentioned, particularly the existing geopolitical issue happening in the Central European region. And not only that, here there were multiple other issues. Some half a decade back, there was a big issue on the economic embargo on a particular country, Kingdom of Qatar, wherein the other Arab nations had an economic embargo. And later there was a successful mediation. even though it took some longer period, it was so effectively concluded without even escalating to a larger scale confrontation. That's very important. And this also we can see whether it is all the global south countries, whether it is going to be geopolitical or ethnic conflicts or whatever the rebel movements, all have been reasonably come to a effective conclusion without escalating with mediation. Whether it is going to be individuals mediating or whether it is the sovereign state mediating. Here, there were a great development of bringing in mediation within arbitration. There were some associations quite early, bodies, whether academic as well as arbitration institutions, which wanted to have a coexistence of both. That coexistence, I feel, US is promoting in the manner as learner in ADR. US is the model from global north that med-R clause has to be accepted. Start with mediation. If the mediation is successful, there ends. If it is unsuccessful, we can take it to arbitration. That a combination, a hybrid, which is being suggested predominantly in the US jurisdiction, which will be taken as a next step for the growth of ADR in Global South and making the Global South to be a future stronghold for arbitrations and mediations. Thank you, Mr. Samir Shah, for spending
Thank you so much.
a late night in US after an enjoyable time with your family, particularly with your daughter getting into her career in US. Thank you.
Yeah, thank you, Imad. Thank you so much. It was real pleasure to be here on this, large global level program on, on ADR. And I think this is the kind of the movement which is required at this stage to make ADR the future of dispute resolution. Thank you so much, Imad. Thank you so much.